Good afternoon. My name is Vicki Redgrave, and I'm Vice President and General Counsel at Technology Concepts and Design. We are very pleased to present this webinar program today in cooperation with the 7th Circuit entitled You and Your Client, Communicating About E-Discovery. Today's webinar is the second in a series of programs intended to provide insight and guidance on how parties can utilize the principles set forth in the 7th Circuit's e-discovery pilot program to encourage cooperation among counsel and transparency in the process for the collection and production of electronically stored information. In the first webinar, entitled Reforming Discovery, our panelists provided a high-level overview of the 7th Circuit's pilot program goals and also spoke to the general application of the principles. For those of you who were not able to join us for that discussion in February, we invite you to go to our website at www.tcdi.com, where the webinar is available for immediate download. Today, we wanted to take the conversation about reforming discovery even a step further and speak to why it is so critical that counsel be adequately informed about the litigation-relevant aspects of their client's data and their computer systems. Given the technical nature of this subject matter, we understand that getting to this point is not always easy. So we've assembled today a very knowledgeable panel of attorneys with extensive e-discovery experience that are prepared to share some practical guidance on how you can start communicating more effectively with your clients on e-discovery issues. Joining me today are Michael Bolton. Mike is Senior Counsel for Baxter International. His responsibilities at Baxter include litigation management for the company's bioscience business. Tiffany Ferguson. Tiffany is a partner at Pugh, Jones, Johnson & Quant. Her litigation practice includes complex employment, personal injury, and white-collar criminal defense and investigations. Chris King. Chris is a partner at Sun & Shine. Chris concentrates his practice in the areas of securities litigation, consumer fraud, antitrust, and other class actions. He also advises clients on e-discovery and records retention practices. And finally, Thomas Staunton. Tom is a partner at Miller, Shackman & Beam. Tom represents clients in a wide range of corporate litigation matters, including partnership disputes, corporate governance, commercial real estate matters, and general contract law. My thanks to all of you for joining us here today. Chris, let me begin with you. The title of today's program is You and Your Client Communicating About E-Discovery. Why do you believe that it is so important for counsel to sit down and talk to their clients about e-discovery matters?
Well, each computer system that is relevant to litigation is different. Whether you're representing an individual litigant or an enterprise or an entity, each computer system is different, and the client knows its own computer system best. The lawyer, on the other hand, knows the legal issues, the factual issues in the case, and the electronic discovery requirements best. And so the two have to get together to share information so the attorney can apply the legal standards to the facts that are specific to that particular case.
Tiffany, what suggestions would you have for someone that may be working with a client that's not very familiar with e-discovery issues?
Well, the first thing is before you can work with the client, I think you have to make sure that you yourself are up to speed on the various e-discovery issues at hand. One of the slides we have in the presentation includes helpful links for educating yourself on e-discovery, and you'll see 4 links that we hope that are helpful in helping practitioners educate themselves on those topics. With regard to a client that's new to e-discovery matters, one, you want to begin educating your client. You want to allay their fears about the e-discovery process. You're going to begin what will become a series of conversations you'll have with the client explaining the scope of e-discovery, but without being overly technical or getting into minutia, particularly for the very early discussions you have with the client. It's not a time to get into hyper-technical information. You want to be in a listening posture. so that you can hear what the client has to say, not only about their systems, but about the very real cost and time, people, and other resources that compliance will cost the client. You want to explain, secondly, the obligation to the client. And generally, the obligations for e-discovery are the same as they are for all discovery that you've worked with in your practice. The differences lie in the volume and the lack of common understanding of how data is created, stored, and overwritten, and the attendant costs of that process. Lastly, you want to counsel and advise. Again, what you would always do with the client in discovery issues. That is why it's important, in order to successfully move through e-discovery, what's most important is assembling the right people or teams to aid you and the client to move through the process. You want to have your internal and external teams assembled, and then start to identify the key people in the company and the people outside of the company that will be aiding you through the process. Lastly, and this is just my own personal recommendation, this is not a time to start a discussion with the client in which you play gotcha with the client, either about their lack of knowledge or as your discussions continue, about things they may have not been aware that they should have informed you about or neglected to tell you about.
Well, one of the key goals of the principles is to incentivize early and informal information exchange on common issues relating to evidence preservation and discovery, both for paper and electronic, which is required by Rule 26F2. Mike, why do you think it is that the principles strongly encourage such early communication?
I think the principles encourage early communication because the courts have seen the consequences of a failure to communicate early. The courts who set up this panel and started this process going see the train wrecks of sanctions motions and motions to compel that come from parties not understanding the technological issues that they have to deal with in e-discovery, and instead dealing with them after the fact. When we can address these issues up front and get basic agreement on the parties on issues like the breadth of preservation, the type and format of collection and the format of production, if we can get agreement on those early on, we can avoid the cost of recollection, the cost of doing an additional deposition, and the burden on the courts of dealing with these disputes. And the principles set this out pretty clearly. Principle 2.01 A and B requires the parties to meet and discuss these issues dealing with preservation, collection, and production even before the initial status conference. The next section of 2.01, paragraph C, points out that these meetings between counsel are much more likely to be productive and lead to agreement if the parties speak if the outside counsel speaks to their client about how their data is stored and retrieved before the meeting with opposing counsel. And then finally, the principles don't just leave this just to the attorneys in the dispute. It also gives the court the ability to take steps to ensure that the parties are cooperating and participating in the meet and confer process. So if you can participate in the process in good faith early on, you can avoid the risks that come up later on.
Tiffany, how would you suggest that counsel begin their discussions with clients on e-discovery issues that might be related to a case?
I think you begin at the beginning. So you start with the complaint, the allegations that are in the complaint, the issues that are raised by the complaint, including damages issues raised by the complaint. You don't want to overlook those, as well as any defenses. I'm a defense lawyer, so as well as any defenses you are likely to raise or have already raised in the course of the litigation that would come up or be indicated by various e-discovery requests you might have in the course of the litigation. Next, we talked about assembling the teams. So in terms of your internal team, you need to identify the key people in the organization that will be helping with this process. Those people can come in many different varieties, but they basically fall into two categories. Custodians, who are the people who actually have the info, may have in some instances created the information, and IT professionals within the company who are going to aid in accessing that information and preserving it. As a practical matter, one of the things I like to consider doing is, again, depending on the nature of the organization and the issues involved, because this will not always be possible, but to actually visit the site where the information or the bulk of the people working with the information are. So that can entail actually looking at a server room, looking at how the employees that are working with the information operate, what devices are they using. In other words, you start your investigation. It's my hope that if you go through this process or in any attempt at an investigation you start making, that through your observations in that investigation, you will be able to indicate to the client things they may not have considered, like their telephone system that may store electronic data. Some telephone systems actually send emails of your voicemails. Mobile information that employees may have in the field, that if they have to report inventory or sales figures, and have a mobile device that does that. Those are the kinds of things that are so ingrained in the company and how they do business that the client may not focus on telling you about, but may be sources of information that are responsive to requests that you have in the litigation.
Chris, Tiffany talks about identifying people and data. What types of data storage are you looking for?
Well, let's start with defining some terms. I think there are two concepts to consider. The first concept are data stores. The second are data types. And here's what I mean by data stores. These are physical locations where the data is located. People like to talk about data floating around in cyberspace, but at the end of the day, that data lives someplace, and the place that it lives is in a data store. The data store could be a file server, it could be a computer workstation, which has a hard drive, or it could be removable media, like, for example, a CD-ROM or a flash drive. The second concept are data types, and these are the types of data that you would find in any particular place. So, for example, one type of data type would be email. Another would be loose files, by which we mean word processing documents, Word files, Excel spreadsheets, PowerPoint presentations, and the like. Or we could be looking at structured data. And generally when we talk about structured data, we're talking about data that is stored and indexed, sorted, and accessible through some type of a database program or combination of database programs. So we've got data stores and data types. So when we go to talk to the client, we might ask, where is the email? Is the email on the email server only? Is it also on computer workstations? Could it be on removable media? Could it be in another location? Practitioners will generally ask about where the loose files are stored. Usually they're on file servers, and what kinds of files are they on the file servers? What kinds of folders? Web pages are a third type of data, and those can be found in a variety of different formats in a variety of different places, and it varies, I think, from individual to individual and from enterprise to enterprise. Structured data are usually in larger enterprise databases, and each of those is unique, and an understanding needs to be gained as to what data is in those locations and how it's organized. And then there's another category of other, and there is a wide variety of different types of electronic data out there. For example, CAD files, computer-aided design files, are found at some businesses. And there are a variety of other different data types. And so the only way to find out about what kinds of data types one is working with is to ask the client, see what the people who are involved in the case work with. And that's what most practitioners, I think, who go to investigate the electronic data that is relevant for a particular case do?
So, if you're representing an individual plaintiff or a defendant, trying to figure out who the key people are related to a matter may not be so difficult, but what about counsel that represent large entities with hundreds or even thousands of employees? Tom, what suggestions can you provide counsel as to how they can begin identifying the key people that they need to talk to in order to find out if they have any relevant electronic data?
Well, consistent with what Tiffany said earlier, I think you need to communicate with at least two categories of people. The first category are people who are likely to have the relevant BSI or electronically stored information. Identifying this group of employees involves a process similar to the one you already go through in identifying witnesses. Who has or who may have knowledge of the relevant facts. Employees with knowledge of relevant facts are likely to have relevant BSI. For example, on a contract page, you should be thinking about employees involved in drafting or negotiating, employees involved in the conduct alleged to have breached the contract, employees with knowledge of financial and damages issues. In an employment case, you should be thinking about decision makers, co-workers, human resources personnel. At the end of the day, you're likely to include on your list everyone you have on your Rule 26A disclosure list. But you also will likely end up going broader than that. Rule 26 is limited to individuals likely to have discoverable information that a party may use to support their claims or defenses. The list of ESI custodians will not be so limited. Then there's a second category of people that you need to communicate with, and that's employees with knowledge of the computer systems likely to have relevant data. Chris just talked about the process of identifying which computer systems have the relevant data. In most cases, it's going to include the email systems and the shared network servers and hard drives for individual employee workstations. Might also include specialized databases for what's referred to as structured data. It's important, at the end of the day, it's important to communicate with people who can explain to you how the relevant computer systems are organized and structured, and who are familiar with any company policies and procedures regarding those computer systems. In a large organization, that might be individual IT professionals or a group of IT professionals. In a smaller organization, you might be talking to an office manager, a department head, a business manager who works with the relevant system.
One of the critical points that needs to be discussed early with a client is the need to preserve electronically stored information. The substance and the length of that conversation could vary depending on a number of factors, such as how sophisticated your client is, whether you've maybe represented that client in the past and so you already have some familiarity with the client's electronic systems, or whether you know if the client already has a litigation hold protocol in place. But overall, the principles really reinforce the common law principle that these discussions really need to take place as early as possible. So once you've decided that your client has a duty to preserve, Mike, what do you think needs to be communicated to your client and the people that you've identified as possessing relevant electronic information about these preservation requirements?
Well, first you have to understand what your client would usually do in the case of legal hold. If you're dealing with a sophisticated client, they may have a legal hold process in place, potentially an online system, a tool they use for this type of collection. Whether your client's sophisticated, though, or less formal, you have to play an active role in evaluating that system because one size does not necessarily fit all. If you see a process or a system in place that isn't going to protect the material which needs to be protected by this piece of litigation, you need actively to engage with your client to make the changes and make the suggestions. You have to play an active role throughout this process and do due diligence when your client talks to you about the system. Make sure you understand it. As Tiffany said, it may mean that you've got to go as far as actually visiting their facility. But in other cases, you just need to educate yourself on the process that's in place with your client. And different clients have different cultures, and those cultures may need to be considered when you consider what process to follow. If we're talking about a client which is a group of computer engineers who meet in a local coffee house, you don't necessarily need to have a written communication of a legal hold to every single one of them if you know that you can have them all in one room and talk to them frankly and certainly about the litigation. On the other hand, if you're talking about a complex, larger piece of litigation in a less centrally organized organization, you'll need to make sure that your client can send out a legal hold notice that communicates exactly what needs to be done here. One thing you may need to educate your client on is that they don't just have to protect materials which are relevant to the litigation and your defense. They also have to document that protection. So you have to work with your client to make sure that they can point to evidence that they can present in court or to their opposing counsel of what they did to make sure that actions and steps were taken to protect the relevant information here. And a lot of that really, again, depends on the nature of the case. The principals really understand this concept that the nature of the case determines what level of behavior is expected in Principle 2.04. That principle deals with the whole issue of proportionality. It requires that the preservation efforts be in proportion to the significance of the litigation. And there's a whole range of factors set out in the rules of 26B2C that allows you to balance the importance of the litigation versus the cost of the discovery. And that expected cost of preservation, or the impact of preservation on a party's operations, for example, can be compared to the likely damages claimed in the matter to decide whether the preservation effort is warranted, falls short, or whether the expenses or costs need to be shared. And importantly, again, you as outside counsel need to play an active role in understanding things that are going to be balanced in that proportionality analysis. You must understand what the risks are of, you must understand what the costs are to your client of putting a hold on, let's say, email deletion. You need to understand what cost your client bears in holding backup tapes so you can use that in front of the court to balance out the issues. At the same time, though, you really need to educate your customer on the risks of not complying here or not making a full effort to preserve this material. When I give presentations internally to demonstrate to my client what is asked of them in the course of litigation, I use the Morgan Stanley case, where the failure of the client to find a backup tape, which they had and eventually produced to the court, the failure of them to produce that in a timely way resulted in a decision that was later overturned that initially was greater than $1 billion. So you need to educate the client, you need to educate yourself in what your client does. And one of the reasons why you need to educate yourself is that you run the risk of being sanctioned yourself. A good example here is the Qualcomm case, where outside counsel was sanctioned, even though they thought they were able to point to their client's behavior and say, we understood that our client had protected all this material. Again, as outside counsel, you have to do due diligence on your client, that they understand the risks, that you know the systems, and that you can argue proportionality in front of the court.
Well, you mentioned that the principals have obligations on the client and the discussion about obligations on you as an outside counsel. Tiffany, can you discuss a little bit more about the obligations that you have as outside counsel representing a client on these issues?
I think, just to follow up on what Mike is saying, the number one obligation is to take it seriously. That seems to go without saying, but as the examples that Mike has pointed out highlight, it can be easy in some instances to just rely on the client and not do your own investigation. So take it seriously and take our responsibility with regard to the steps that are necessary to accomplish that. We've been talking about an ongoing dialogue with the client. That ongoing dialogue needs to be open and frank. I think it's a word that was used earlier in this discussion. That frank discussion is what you are trying to have with the client. And that is key to avoiding a situation like a Morgan Stanley case. One way to put it to the client is that almost any problem with regard to e-discovery, including instances where things may be overwritten in the normal course of business, almost all of those problems can be addressed effectively before the court with the requesting party if you are aware of them and aware of them early. They all have different ramifications when those problems occur, but the worst case scenario, obviously, is that counsel does not know that a problem has occurred and is in a position of making representations to the court without that information. So the ongoing dialogue with the client. Secondly, your obligations as an officer of the court, which I began to talk about. That same frank discussion that you are having with your client and your representations to the court, particularly when there are problems, you want to have a frank discussion with the court and as to the problem and what steps you have taken, hopefully by that time, to rectify it. You also want to be frank in just your what seem to be routine representations to the court, like often an e-discovery request may be burdensome to your client. The thing you do is you go into court and explain if there's an impasse with the requesting party why the request is burdensome. You can be making representations in that discussion with the court that are inaccurate if you have not talked to the key IT professionals in the company that actually know the steps necessary to produce the information. So I make a point to talk to the person who will be running the report or producing the data, whatever it is that has to be done. If we're saying it's burdensome, I need to speak to the people who would actually have to do the work, the physical work of running the report, looking at the information, doing the research, whatever it is, to produce the data. Lastly, your obligations are what they were at the beginning of the litigation. You want to locate the information, preserve it, and where it's responsive, produce it.
Chris, do you have any thoughts as to what are some of the topics that you think are important for counsel really to discuss with their client regarding preservation?
Sure. I think that the subjects to discuss with the client are going to vary from case to case, going to depend on the nature of who the parties are, the nature of their business if they're an enterprise, and the legal and factual issues in the case. Most practitioners, though, will ask about the following things. With respect to email, they'll inquire whether there is any type of an auto-deletion function that is used with the email system, such as mail managers. They may also ask whether the email administrators impose what are called mailbox quotas, which are essentially size limits on the amount of data that can be saved to an email file. With respect to loose files, which we defined as Microsoft Word documents, spreadsheets, presentations, that sort of thing, they may ask whether there's any kind of a document management system, such as the ones that many law firms use, like DocsOpen. Most companies don't have file management, document management systems, but some do. And so many practitioners will ask about that. With respect to databases, many practitioners will ask how the data is inputted and saved to the database. Is data overwritten? Is it saved? Are there historical records created? With respect to web pages, practitioners will ask, is there any kind of a content management system associated with the web pages? Storage. In the old days, there was active data, and then there were backup tapes, and there was nothing in between. Today, there are a wide variety of different storage solutions that people or companies may use, many of which make the data fairly easily accessible, perhaps not as accessible as active data, but it falls into a general category that some of the cases call nearline storage, and that's useful to find out about. Finally, backups. Most companies that do disaster recovery backups rotate and recycle their backup media. Most people ask about what the schedule is for those backups. I will note that in Principle 2.04D, the principles provide that backup data is generally not discoverable, but it is something that many people think should be inquired about early on. So those are the types of questions that may be appropriate for any particular case.
Tom, what about the use of preservation letters? Do the principals provide any guidance on the use of letters like this?
Just to start off, I think a number of our listeners may have sent or received preservation letters, just so we're all on the same page, talking about letters that are sent that request or demand that the opposing party preserve certain information. These letters are often sent by plaintiffs, and they're often sent before a complaint is even filed. In talking to your client about preservation letters and responses to preservation letters, it's important to remember that the preservation obligation is a common law obligation, not dependent upon sending out a letter. The principles reflect that fact as they take a neutral position on preservation letters, neither encouraging them or discouraging them. Principle 2.04A confirms the common law obligation. Principle 2.03D expressly states that nothing in the principles shall be construed as requiring a preservation letter or a response to a preservation letter. I will note that Principle 2.04D lists a number of various categories of data that are generally not discoverable. And the principle states that if you know these categories are relevant, you should raise that at the meet and confer conference. It's possible that you could also choose to raise those categories of data in a preservation letter. If you know that, for instance, temporary internet files are going to be crucial to your case, then maybe you want to raise that as early as possible. In many ways, the principles, by encouraging communication and cooperation, make the use of preservation letters less important. But back to the principles again. Instead of directing counsel to use or not use them, the principles focus on certain goals counsel should be trying to achieve if they choose to send a preservation letter. The principles make it clear that preservation letters should not be used to gain leverage over an opponent, an opposing party, or to play a game of gotcha to set up opposing parties for spoliation claims. Rather, as stated in Principle 2.03b, preservation letters, if they are used, should be used for the two goals. First, ensuring the preservation of relevant and discoverable information. That's the key thing here, is that everybody wants to preserve the information that is going to be relevant to the case. And the second goal that these letters should serve is facilitating cooperation between requesting and receiving counsel. Principle 2.03b goes into further detail about how a party that chooses to send out a preservation letter can serve those goals. It states that the focus should be on providing specific and useful information. Principle 2.03 provides some examples. Many of those examples illustrate the fact that these letters are frequently sent out before the complaint is even filed. In the absence of a complaint, a party receiving a letter needs basic information about the parties, the claims, the relevant time frame, in order to make any reasonable assessment about preservation. The principles also cite other information that can help with that assessment, including identification of potential witnesses. The approach in the principles to responses to preservation letters is similar. Principles do not require that any response be served. As a practical matter, many lawyers advise their clients to respond. One common approach to this issue is to consult with your client to determine a reasonable approach to preservation and then communicate that approach to opposing counsel as clearly as possible. Formulating those responses can be a challenge, though, if the complaint has not yet been filed and if the preservation letter does not contain the type of specific and useful information that's described in Principle 2.03. But even in that situation, a response can be useful, even if it's largely to explain that you need additional information. Overall, the principles recognize and reaffirm the fact that whenever this discussion over preservation occurs, whether it's part of an exchange of preservation letters or whether it's later as part of a meet and confer in advance of the initial status hearing, It's much more likely to be productive if, rather than posturing or threatening, the parties engage in specific discussions about the issues of the case and steps both parties believe are necessary and reasonable to ensure the preservation of relevant and discoverable information.
Well, so far we've talked about the need to know your client systems, how to identify key players, and what potential issues that you need to consider related to preservation of electronically stored information. Another important topic that needs to be discussed with your clients is the collection of the ESI that you've identified. Tom, what suggestions do you have for counsel on this topic of discussion?
So once you've talked to the client and identified the relevant data types, as Chris talked about earlier, you need to have further discussions with your client about where and how your client, including the individual custodians, the individual employees who have substantive knowledge about the issues in the case, where your client stores and maintains those data types or those files. For example, in every case, email and loose files, as Chris described, the loose files are word processing documents, spreadsheets, Microsoft Office type of documents. In every case, email and loose files are likely to be relevant. In order to gain an understanding of where to find those files for the relevant custodians and how those files are maintained, you're going to need to communicate with two categories of people as clients. This is similar to what we've discussed a couple times now, but you're going to have to keep going back to these people, either going back to them or having one omnibus discussion with them. But anyway, you're going to need to communicate with these relevant players. The first category is the IT people, the employees who know about the rules of the systems on which the emails and those files are kept. For emails, those employees might be able to address a number of issues, including whether emails are stored on a central server or on the individual employee's hard drives, or both, whether email archives exist, whether there are any firm-wide policies or procedures regarding individual employees' use of email. For loose files, you might need to know whether the company has network servers or a series of network servers, which most companies of any significant size will have. You also need to know the defaults that apply to the creation and editing of Microsoft Office type documents, these loose file documents. As a default matter, are those documents going to be stored on the network server that can be collected centrally? Again, we're talking about collection here. Or are they going to be on an individual user's hard drive? Are you going to have to go out to 15, 20 different hard drives and collect those? If other types of data are relevant, you also need to talk to these system people about how and where those types of data are stored and maintained. Again, the second category of people you're going to need to communicate with are the individual users who created, maintained, modified, used the relevant data, the witnesses and custodians that we talked about earlier. In order to properly collect ESI or electronically stored information, you need to know how the relevant witnesses create, use, and save their data. For example, where do witnesses save their email? Do they save them on the company server, or do they copy some on their hard drives? Do they create additional emails or documents on their handheld devices? If they do so, do they regularly sync those devices with their PC or their network system? When they create word processing documents and spreadsheets, do they save them in a shared network folder or on their hard drive, or both? Do they save them on their secretary's hard drive? What role does their secretary play in the creation of documents more generally? Do they ever use a home computer for work? How do they use their PDAs or their BlackBerries or their iPhones generally? Once you've had these communications, you and your client can put together a reasonable strategy for collection of relevant ESI. But once you've done that, there is one additional step that I would recommend, certainly, and it's a step that I think has come up in this discussion and will come up again, and that is talk to the other side. Before you go forward with the collection, seek agreement from opposing counsel. Send him or her a letter describing what you think is a reasonable approach to collection and production. And we're going to be talking about production, I think, a little bit later, but collection and production are necessarily tied together. Send him or her a letter with your proposed protocol and ask for an agreement. Collection can be extremely expensive, time-consuming, and this is one thing that people don't always think about. I think it can be extremely disruptive for the client and its employees. So you need to make sure you only do it once. And once you describe the protocol to the other side, follow up with discussions, attempt to reach an agreement about what's reasonable, If you cannot reach an agreement and you think opposing counsel is being unreasonable, go to the court and ask the court to approve your approach.
Well, one of the things you talked about earlier, Chris, were backup tapes and talked about expense and sometimes difficulties for clients. Oftentimes people will raise the question, do you always have to get information off of backup tapes? Chris, your thoughts on that?
Sure. I think that the principles and the case law have established that backup tapes are not usually subject to discovery. And the reason for that is that in most instances, backups are going to be duplicative of what is generally available in active storage, although there certainly will be exceptions from case to case. Let's pause for a moment here and define what we mean by a backup. When most courts have addressed the issue of backups, they're talking about disaster recovery backup media. And the purpose for which these media are created are to recreate a large, complex computer environment if there's a disastrous loss of data. And so what that means is that this data was created, organized, and stored to recreate a computer environment and not to provide discovery of a specific item that's called for in a lawsuit. And so generally, the reason that restoring backups can be so expensive can be found, first of all, in the nature of the data. It's compressed. You can't just plug it into a computer and pull it up and read it. It has to be uncompressed. Quite frequently, the data can only be recreated in an exact duplicate computer environment, which means all the files have to be set up exactly on the way that the computer that crashed was organized. And so what that means is, again, you can't just take the backup tape and plug it into a computer and read it. What's more, locating the data on the backup tapes can often be quite time-consuming and expensive. The reason is that most backup systems save the data in a way that's most efficient to compress a large amount of data into as small a space as possible so that the computer environment can be restored in the case of a disastrous loss of data. And so, whereas if you're looking for a particular email file, it may be on tape 1 in Friday's backup and on tape 263 in Monday's backup. And so, finding things on computer backup media can be very time-consuming and very expensive.
So, what other types of data can present some unique collection issues?
Well, there's a wide variety of different types of data out there, many of which present collection issues. But let me just mention two of the ones that some of our listeners may be more likely to encounter. The first are what I'll call non-standard email platforms. And by non-standard, we mean anything other than Outlook from Microsoft. And the reason that these, what I'll call non-standard email platforms present collection challenges is very simple. Most of the vendors, and even if you're going to do the collection yourself, you're going to be using certain software tools, are designed to work in a Microsoft Outlook world. And when one encounters a case that with a client who's not using Microsoft Outlook, then you have to adapt, and especially if you're hiring vendors, it's important to ask and get some references as to whether that vendor is accustomed to dealing with that non-standard platform, because the file formats of the different email platforms are radically different. And it's very important to understand whether the vendor has that experience. Second would be databases and structured data stores. And here, to go back to the definition that we provided earlier, These are stores of usually large amounts of data that are stored by an organization. It could be a company, it could be a governmental agency, it could be a not-for-profit. And these databases are, for the most part, unique. And so even if you have the same software that's been used to create an enterprise database at company A, that same software at company B will have been configured quite differently. Most of these databases can be customized and have been designed by companies to format the information for the efficient use of the company in conducting its business and not for purposes of responding to discovery requests or inquiries from lawyers. When getting information off of databases, a key question to ask is, do I need a report of the data or do I need the data itself? As the principles discuss, in many instances, a report of the data will suffice. So, for example, if you need to know how many widgets were sold in the following 6 states during a particular time period, you don't need the data relating to every one of those widget sales. You probably don't even want it. What you really want is a report that tells you how many widgets were sold in those particular states during that time period. And that's a report. And then the next thing to ask is, okay, if a report's going to do, can I make do with an existing report format? Is there an existing report format that's already been written that I can use to answer my question? And in those instances, that should suffice with respect to discovery. In some instances, custom reports will have to be written. Usually that requires some programming, and there's some expense involved there, which if you're on the producing side, you may want to look into cost shifting. There will be some cases, however, especially where there's any kind of statistical analysis being done, where the actual raw data needs to be produced. And in those circumstances, to go back to something Tom said a minute ago, it is very important that you have a discussion with the other side and agree upon the format of data to be presented to the other side, so you only have to do it once. Talk in advance, work out an agreement, reduce it to writing. It is this type of dialogue and cooperation that the principles are intended to promote.
Well, Chris just talked about some of the issues that can come up with collection. Do you think that clients can handle collections internally, or do you think it's necessary that they always have to go out and get an outside vendor to work with them?
And again, the answer to this is it always depends on the nature of the case. The issues that Chris raised, the complexity of different types of data, different types of systems, that's one issue you have to ask about. Can your internal IT team collect this material and be trusted with it? But then you can also look at the volume of data that's out there, the number of custodians, whether you have to go to each individual custodian to collect the material or whether you can collect it from one central location. These all relate to whether you can have your in-house team handle it. And you have to ask yourself, are they able to give this priority attention, or will this get put in the list behind the many things that your group is already working on? For outside counsel, you may be acutely aware of the sensitivity of the issues in the case, and whether that dictates whether this can be done by an in-house team or outside contractors. If you have a case that alleges that, an employment case that alleges that an employee was harassed by people in the IT organization, that's a case where you won't want to have the IT organization collecting the emails. Ultimately, you'll also have to decide how important is the collection issue. Will people have to appear in court and testify about it? View this as you view bringing up an expert in a matter. Many corporations will have someone in-house who can act as an expert in the issues in a case, but you choose not to use that in-house expert because you want someone who will be unbiased and will appear that they're really making their decision from their background and their history and their expertise rather than because they're employed by a party. In those situations when collection and e-discovery will be key, that's when there's more weight in favor of bringing in someone from the outside to do the work.
Well, the principles also give parties guidance on considerations that are related to the production of ESI. Tom, what's been your experiences to some of the most commonly encountered forms of electronically stored information and the issues that might be encountered when you're dealing with their production format?
Rule 34B2 requires production in a form in which the ESI is ordinarily maintained or in a reasonably usable form. The principles don't dictate that the ESI be produced in any particular form. They do direct counsel to address format of production issues early in the case and raise any disputes with the court. That's in Principle 2.06a. They also lay down some ground rules on certain specific production issues that I won't go into detail here, but they're in Principles 2.06b, c, and d. To address your question more directly, the most commonly encountered forms of ESI are emails and loose files, which we've talked about a couple times today. They need to be produced in almost every case. For emails and loose files, this Rule 34 calculus generally comes down to whether to produce, number one, in native form, which is the form in which the file is maintained on your client's computer systems, or number two, in a format that is essentially a picture or an image. Frequently this is in a format called TIFF. When ESI is produced in TIFF format, the production will frequently also include a load file that contains metadata or information about each file. In the case of email, for example, the production might include a TIFF image of the email accompanied by a load file that identifies the date, the author, the recipient, the text of the email. Native productions present certain challenges that can make litigation more complicated. And although they're more expensive and complicated than paper productions, TIFF productions are similar in some ways to paper productions. The vendor can burn a base number on each image, and each party has the exact same image. You're working with the exact same document. The image doesn't change. It makes it much easier to use documents in depositions and hearings and in connection with motions. Native files, on the other hand, can be more complicated to work with. There are situations in which native productions are necessary and make sense. Some attorneys will argue that one such situation is the production of Excel spreadsheets. Spreadsheets, by their nature, contain information that is difficult to capture in an image. The user might have chosen to hide certain columns or rows or cells. The formulas in the spreadsheet, rather than simply the results of those formulas, might contain relevant information. There are ways to address these issues. One approach is to produce TIFFs with a load file, but permit the requesting party to request native versions of individual files in the production as they come across files that they need an individual native production. Overall, this process works best when you talk to opposing counsel, as we've said several times today, I think. If opposing counsel is demanding something that you think is unreasonable, make him or her explain why. Why is a native production necessary? Why do we need a production with 32 fields of metadata? And during these discussions, there are two related concepts that might come up or that you might wish to raise. The first is proportionality, which I think has come up a couple times today, which is addressed in Rule 26B2C of the Federal Rules of Civil Procedure. I'm not going to read the provision here, but the general concept is discovery may be limited under certain circumstances, including where its burden or expense outweighs its likely benefit. Issues of burden and expense frequently come up in the context of requests for data on backup tapes or other inactive data, which Chris has talked about. But burden and expense can also be a factor in format production issues. There is a separate principle, Principle 1.03, that is dedicated to proportionality. It states that the parties should apply proportionality principles in formulating their discovery plan. And the best way to ensure proportionality is for parties to always make sure the requests and responses are targeted, clear, and specific. A second related concept that might come up in your discussions with opposing counsel is cost shifting. One way to address some of the issues of burden and expense that come up in connection with format production. It can be difficult to shift costs in the ordinary case. And cost shifting does not always solve the problem. Overbroad productions can be extremely disruptive to the client, and they can lead to additional expense in the form of additional attorney hours for attorney review of the additional discovery being produced. And it can be very difficult to shift or compensate for these types of costs. The cost shifting can be useful in some cases where counsel insisting on a broader production where necessary, or production in a form that is burdensome, can be useful to introduce the concept of cost shifting into the equation. Finally, just to reiterate, it's come up a few times today, but it's very important as the producing party that you get opposing counsel's agreement to your proposed form of production. And counsel your protocol in writing. Counsel does not agree to it to discuss why production needs to be in Form A or Form B. And if you can't reach agreement, you believe opposing counsel is being unreasonable, seek relief from the court. The exact productions can be expensive, and you only want to do it once.
Tiffany, is there anything that you might suggest that counsel could keep in mind during their collection activities in order to help them manage production issues?
The one thing you want to keep in mind is that you want to be sure to protect the integrity of the data. So while you're having this discussion with opposing counsel about format, how the information is going to be produced, which I might add, ultimately the goal of any requesting party is to get the information. And generally, if everybody keeps that goal in mind, even in contentious litigation, you can reach some agreement about format. Rule 206 of the Principles talks about, Principle 206 talks about the idea of the parties to have cooperation. If that fails and you have to turn to the court, again, the focus of that discussion is the information and not so much getting into the difficulties with different formats if there's impasse reached between you and the requesting party. But again, while you're having that discussion with opposing counsel and with your client, you want to be sure that your client is taking steps to preserve the integrity of the information. Because the last thing you want to have happen is that while you were having these debates with the requesting party about the format, that somehow the data has now been overwritten. This is particularly true, well, not particularly true, but they're unique issues with regard to databases in this regard, particularly databases that the company is using, like a lot of them, in the active conduct of its business. In those instances, you want to be sure that information is not overwritten and that that data is isolated so that when you start to have this discussion, and ultimately if you have to go before the court about why production formats are a problem for this database. Again, as Chris explained, databases can be very unique. Some are proprietary. They've been designed generally just for the client or modified such that they are unique to the client's needs. You want to make sure that the information is there so that ultimately when you are able to reach an agreement or the court provides you with some relief, you have information to produce. Lastly, we've talked about cost shifting. When we talk about formats, again, the question that comes up is what, and this is true for the general types of e-discovery we've been talking about, and in particular for a databases, is it necessary to have a customized report for the information that's being requested? If that is the case, that is, it's custom in that some IT professional has to run a script or which is another term for a program that has to be run on a database or other types of e-discovery. If that is the case, that there is some custom, unique thing going on for purposes of the litigation and not that would occur in the normal course of the client's business, that's the time to, again, as has been explained, to start suggesting to the requesting party that perhaps we need to shift costs here with regard to the production of this information. And if you're already before the court, to explain that to the court with having educated yourself about what the burden is to your client because of the customization that's required by the request.
Well, I know we're almost at the end of our time, but we've had a number of questions come in about e-discovery liaisons, and I want to make sure that we touch on that briefly before we wrap this up. And just for everybody's information, Principle 2.02 calls for the designation of an individual or individuals that serve in this new role, specifically when a dispute concerning preservation or production of electronically stored information happens. Chris, can you give us a little bit of background as to why the pilot program drafting committee decided to include this role, and a little bit more information as to what the role's intended function, and whether this is a position that parties will have to have filled in every case?
Well, I think that the committee included a provision in the principles on liaisons because judges in many jurisdictions have found e-discovery liaisons to be so useful and so helpful to them. Virtually every electronic discovery program that I attend that has judges speaking, the judges complain about their frustrations in getting accurate, timely, understandable information on electronic discovery issues when they come up in the litigation. In fact, in one of the early electronic discovery decisions, in one of the Zubilake opinions by Judge Steinlin, she started the opinion with a quote from a movie in which the line is, "What we have here is a failure of communication." And if just about any judge who has encountered electronic discovery issues in their cases will tell you that that's one of the major problems that they perceive. Now, in many instances, I think many cases, e-discovery liaisons may not be necessary. But I think that certainly in any large and complex litigation, it's very useful for the parties to designate e-discovery liaisons, frankly, even before a dispute arises, because maybe if all the e-discovery liaisons talk to one another, maybe there won't be a dispute, which is, I think, everyone's goal.
Any thoughts on who counsel or the client should consider to fill this position? What kind of background or roles that they need to have?
Sure. I think it's going to vary a lot depending on the issues in the case, who the parties are, and the nature of the technology involved. In some instances, it may be litigation counsel. If the litigation counsel feels they have adequate technical knowledge, then I think that you see that. Sometimes it'll be a paralegal, particularly for cases in which production format is the major issue. If you have a case where you have enterprise systems such as these large structured data stores and databases that we've been talking about, a client representative may be most useful. Or if litigation counsel is perhaps not as comfortable with technology, they may wish to use a consultant. And I think that it's perfectly fine to have more than one. Because if you have a complex case with lots of specialized technology, you may need particular specialized knowledge to address these issues. And as long as the information, the parties are communicating and the judge is getting the information that he or she wants, I would guess the judge will be more than happy to have more than one liaison. As far as their role, it's to know the data types and data stores and to communicate accurately, both with co-counsel and opposing counsel and with the court.
Well, I want to thank all of our panelists today for their participation. On your screen are some useful links where information regarding the pilot program can and will be found. Also, we've received a number of questions today. These are being captured and they will be consolidated and reviewed and will be used in preparation of frequently asked questions, which will be posted on the 7th Circuit Bar website in the near future. Finally, CLE credits have been approved for the state of Illinois. We have made application for the states of Indiana and Wisconsin. At the end of today's webinar, our listeners will receive an email link for a course evaluation, and upon your completion of the course evaluation, you will receive a certificate of attendance which you can utilize for your CLE submission. Again, my thanks to our panelists and for everyone who's listened in today.